All right, hello everyone. Thank you all so much for joining us. This is Left Bank Books welcomes civil rights lawyer and a law professor at the University of Louisville in Kentucky, Dan Canon, who will discuss the blistering critique of America's assembly line approach to criminal justice, Pleading Out: How Plea Bargaining Creates a Permanent Criminal Class. Tonight, Canon will be in conversation with author and associate professor of law at Drexel University, Adam Benforado. Left Bank Books is St. Louis's oldest independent bookstore. We would like to thank all of our supporters, the supporters of Dan and Adam, and everyone for their outpouring of love for our bookstore. Left Bank Books offers in-store shopping, curbside pickup, and delivery to anywhere in the country, anywhere in the world. We are happy to be able to bring our event series virtual. We believe that events are a way to expand your mind and bring in new thoughts to make the world a better place. We hope that you enjoy this event, and we hope that you support Left Bank Books by purchasing a signed copy for you or for your friends on our website, left-bank.com. Purchasing a signed copy of the book from Left Bank Books allows us to keep our bookstore and staff operating, and it allows us to continue bringing you incredible authors like those speaking this evening. So we thank you for your support. I'm Shane Mullen. I'm the events coordinator for Left Bank Books. We produce hundreds of author events each year with a fantastic team here in St. Louis. We will be taking questions from you, the audience, at the end of the event, so please type your questions as a comment. And you can do that at any point in time as you think about the question. And be sure to follow Left Bank Books on Facebook and YouTube to be notified about all of our fantastic virtual events. And now, about tonight's book. Pleading Out: A blistering critique of America's assembly line approach to criminal justice and the shameful practice at its core, the plea bargain. Most Americans believe that the jury trial is the backbone of our criminal justice system, but in fact, the vast majority of cases never make it to trial. Almost all criminal convictions are the result of a plea bargain, a deal made entirely out of the public eye. Law professor and civil rights lawyer Dan Canon argues that plea bargaining may swiftly dispose of cases, but also fuels an unjust system. This practice produces a massive underclass of people who are restricted from voting, working, and otherwise participating in society. And while innocent people plead guilty to crimes they did not commit in exchange for lesser sentences, the truly guilty can get away with murder. With heart-wrenching stories, fierce urgency, and an insider's perspective, Pleading Out exposes the ugly truth about what's wrong with America's criminal justice system today, and offers a prescription for meaningful change. Kirkus Review says, a full-throated denunciation of a judicial system grown lazy, complacent, and overly given to forcing confessions for its own convenience. A compelling document of interest to anyone concerned with civil rights and an equitable system of justice. And Adam Benforado, our conversation partner this evening, says, to understand the tragic failure of American criminal justice, you must understand the scourge of plea bargaining. To understand plea bargaining, read this book. With riveting storytelling and sharp analysis, Canon describes the everyday monstrosity, unchecked and ruinous, lurking behind the legal system's closed doors. And now, about our speakers this evening. Dan Canon is a civil rights lawyer and a law professor at the University of Louisville in Kentucky. In his practice, he has served as counsel for plaintiffs in the U.S. Supreme Court case Obergefell v. Hodges, which brought marriage equality to all 50 states, and in a number of other high-profile cases. He lives in southern Indiana. And tonight, he will be in conversation with Adam Benforado. Adam is an associate professor of law at Drexel University. A graduate of Yale College and Harvard Law School, he served as a federal appellate law clerk and an attorney at Jenner & Block. He has published numerous scholarly articles, and his op-eds and essays have appeared in a variety of publications, including the Washington Post, the Philadelphia Inquirer, and Legal Times. He lives in Philadelphia with his wife and daughter. And now, I would like you to help us welcome our guests for the evening, Dan Canon and Adam Benforado for Left Bank Books. If everyone would please applaud and give them a healthy welcome to the screen. Hello.
Hello there.
We have a fantastic crowd already here, ready to hear this incredible conversation. And I'm going to turn this over to both of you.
Thanks so much.
I felt like I could hear the applause.
It's echoing there. If you imagine it.
I think it was mostly for you, though, Adam. I don't know.
We'll never know. So Dan, right out of the gate, I just want to say, I really love this book. Obviously, I'm your core audience. I am a criminal justice nerd. But one of the things that I really liked about this book is how, this is bringing the message to the masses. This is a book, I think, that you can shed light on something that really only scholars talk about, but it's so vital to the current direction of our country. And so I just want to start off by saying you have a fan in me, but I'm not giving you any softball questions, despite being a fan.
I would expect no less than
all right,
to be put right on the rack. Yeah,
that's fair. That's fair. So out of the gate, what I'm curious to kind of hear from you, because I think this is helpful to our audience, is just how prevalent is plea bargaining? I mean, I have my first year law students in criminal law, and we have a case book, and the cases, to have a case, you have a trial. And so the assumption of every one of my students getting in here is, well, this must be how we do criminal law in the United States. But is it?
Well, there's so much emphasis in the law schools still, right, on the trial. And students that come in that want to be trial lawyers. And that's why they went to law school in the first place. And, I've seen all these wonderful procedurals and movies and everything else that romanticize the trial. And isn't this how we do things? But it's not. I mean, especially for criminal cases, civil cases are a whole other thing. We're not really doing civil trials either. But for criminal cases, which is what the book is about, we're at 2 to 3% of all criminal cases go to trial right now, and the number is shrinking. It gets smaller somehow. Smaller and smaller every year, even though it's already infinitely small, it manages to find more infinite smallness, so the remaining 97 to 98% right now are all resolved via guilty pleas. And the vast majority of those are the result of a plea bargain, because prosecutors, we've decided we're going to give prosecutors whatever power they want, whatever carrot and whatever stick, and anything that they can possibly throw at a defendant is fair game, to get them to fold up and give up their right to trial. And so that's where we are.
Yeah, and so you bring up an interesting point, which is, and I have definitely observed this, which is we kind of sell a different system to the public than the one that we deliver. And we sell that on television, we sell it in our novels and books. It's to glamorize the trial, and yet something else is what we do in practice behind closed doors. And so I guess my follow-up question is just, how did we get to this point? Is it the case that we've always been doing this, or is this a relatively recent phenomenon?
Well, it's not that we've always been doing it, and it's not terribly recent. So, it's a big answer. So I'm just going to go, and you stop me and break in if you need to shut me up, because my students will tell you that I'll just sit here and ramble all day. But yeah, we're able to get away with this sort of depiction of the jury trial as being the justice system, because we've totally divorced the community from the criminal justice system. And most people, about 2/3 of all people that aren't really justice involved, 2/3 of the entire adult population at this point, don't really know what it's like, outside of like movies and TVs, because they've never had to set foot in a courthouse and never really had to have any meaningful contact with the criminal justice system. So it's like you develop this picture in your head and you never have that challenge necessarily, unless you go to law school, right? Something like that. But to answer your question, you've got the plea bargaining started in New England sometime around the 1830s, as best as we can tell. And that's about the same time that the courts were really interested in trying to break the back of organized labor. And that's a big theme that runs throughout the book, is that, you've got the criminal law that's being used to break up working class solidarity because the ruling classes were getting scared of a gigantic working class in post-industrial revolution New England. So 1830s alone, you've got, in Boston, you've got a 51% increase of the population. And most of those folks are, emigrating in to work in the mills and to work in industry. And there's, they're European immigrants, they're all kinds of different people. And these people are living on top of each other, and they're developing communities, and they're becoming class conscious. And so you've got, a ruling class that then is starting to go, well, this is not good. What's going to happen to us, because these are folks that will occasionally get together for the weekend and go burn down a governor's mansion or something like that. So the strategy of whacking these guys with the criminal law, just prosecuting a bunch of workers all at one time for under a conspiracy statute or something like that, just wasn't going to work. It became too risky. Also, at the same time, you've got the expansion of universal white male suffrage. That's almost everywhere by 1830. So you have working class men sitting on juries, and these folks are often quite sympathetic to the working class. So,
especially if it's a jury of your peers, right? These are people who are your compatriots in your community.
Right. And so you have things like, witnesses for the prosecution getting beaten up outside of courthouses and stuff like that, and so there's this real, I think legitimate fear that if they just keep pounding away at the working classes, at workers who are trying to organize with the criminal law, they're going to lose legitimacy, and their heads are going to end up on a pike. So you see at that point in time, juries start to lose their powers. And for those that don't know this, and I didn't really know much about this until I started researching for the book, juries at that time were immensely powerful because they could say not only what the facts of the case were, but what the law was in most places. And so not only, can they make the ultimate decision as to whether or not the guy ran the red light, but also whether or not it should be illegal to run a red light in the first place. So juries are immensely powerful. And so, what happens is they start getting stripped of their powers. The ruling classes, the elites in New England, start stripping them of their powers. It's a really controversial thing to do at the time, but ultimately they won out. Jury trials are getting more complicated. They're getting less accessible to the working classes, and they're getting, and the juries themselves are getting less powerful. And so elites in New England still need to figure out ways to break up working class solidarity. So they switch to a strategy of just criminalizing all the individual behaviors of the individual workers instead. And in the 1830s, you see this sort of earnest movement towards prohibition as a legal thing for the first time ever. And by prosecuting a critical mass of workers, the ruling classes could really do two things. And one is to bring those workers under the control of the state to a degree and keep an eye on them. The other one is and this is another big theme that runs throughout the book, is to attach the stigma of the criminal label to them, right? Calling them criminals means a lot. And it helps to alienate them from their communities. It disrupts working class solidarity. It pits people against each other.
I think that's, just to pause on that, I think that's a really important point that you kind of make, right? Which is, I like to tell my students at the first day of class in criminal law, like, this is a course about how we make people criminals. Like, I think a lot of people think, oh, criminals are something that's just out there in the public, but no, that's something that the elites get to decide who is a criminal and who is not a criminal. And I love this historical story that you're telling us here.
Yeah, well, it's history and it's psychology. And I can't, I mean, like, I'm just dipping my little toes into psychology. You're like, immersed. So, but I mean, all this stuff, and you can probably talk a blue streak about it. But I mean, there's an ancient stigma that is associated with somebody who's been categorized as a criminal. Just calling somebody criminal is a big deal. Like when you identify somebody as a criminal, you're necessarily downgrading that person's station in life, wherever and whoever they are, whatever rung on the social ladder they're on, they can always come down one by being labeled a criminal. And that sort of throws a wet blanket on any collaborative effort that you might have been thinking under. I was going to gang up with this person and burn down the governor's mansion over the weekend, but that person's a criminal, and so I think I'm going to keep them at arm's length. And society at large has this sort of natural, ancient aversion to criminals. And that's an aversion that's persisted for ages, even after we've removed a lot of the moral justifications for the criminal laws that we have.
Yeah, and I think, one other interesting aspect of that, I teach a course called Law and Mind Sciences, and we just got through talking about actually like threats to the status quo. And when people are afraid, they're afraid for their own mortality. They're thinking about their own mortality. They're thinking about crime and the threat to them. That actually helps preserve the status quo. It's called system justification, that when we fear things, whether that's an external threat or something internal, we tend to rally around the flag. And so you can see how the creation of the criminal and the playing up of the threat of the criminal can be incredibly valuable to those in power.
Yeah, and what's so interesting to me about the psychological studies that have been done about the criminal label, applying the criminal label to somebody, is that, not only do we not want to play in the same sandbox with criminals, but they don't want to play either. Like once you put that label on them, then they start to sort of, a person will start to sort of internalize that and withdraw from society and, take on more antisocial behaviors and recidivate and all these other, things. And especially so, I think, and I'm getting ahead of myself, but I mean, especially so if they feel like they've taken on that mantle voluntarily, you know what I'm saying? And that's sort of the genius of plea bargaining, where it's like you signed up for it. You took this on, you made the contract with the state, and said, yeah, I'm gonna now be part of this, gigantic criminal class. But if you go back to the 1830s time period, plea bargain just became a way to make lots and lots of people into criminals in a short amount of time. So it takes cases away from the jury, which was a helpful function for the ruling classes, but it also just creates this giant criminal underclass and disrupts working class solidarity.
So, I mean, I think that story is so interesting. I think that's one of the really nice contributions of this book, because, I think the common story that people tell today about why we have plea bargaining is it's just like, we have too many cases. We can't deal with them all. It's simply a resources story. And I think the thread that you have really nicely pulled out here is one of, no, actually, this is a deeper theme here. This is about, classism and fighting. And I wanted to actually bring in another, aspect of this story, which is the race part of that. So, I mean, how does that fit into the overall plea bargaining picture in the United States?
Yeah. So if within the 20th century, you've got this gigantic expansion of the criminal law that lands us where we are today. It really begins in earnest during Prohibition. So 1919, Prohibition hits, and the feds get into the game of enforcing the criminal law, which is not a thing that they were really doing so much in earnest beforehand. So, post-Volstead Act, you've got this explosion of different things in the states and at the federal level that are becoming illegal. And at the same time, there's this sort of urgency. And I've got some quotes from Herbert Hoover's inaugural address, and his whole thing is expediency and the criminal justice system. We got to lock up a lot of people, and we got to do it really fast. and the prison population, the federal prison population, blows up between, I think, 1920 and 1933 at the end of Prohibition. It triples. And so all these different things are being made criminal, and at the same time, it's like, well, we got all this new crime and all these new criminals to catch. And so what are we going to do? We got to, and that's sort of the mindset that we've maintained into today. Is that there's so much crime out there, and it's not that we're criminalizing too much stuff. It's just that there's too many criminals and too much crime, and we have to go out there. And when in fact anybody could be breaking, at this point, anybody could be breaking, 10 different laws, just as we sit here. We probably are. I don't know. So you've got this gigantic explosion in the criminal code to where everybody can be breaking some kind of law at any point in time. And I quote a guy in the book, a scholar named William Stuntz, who says something to the, I'm paraphrasing, but something to the effect of, all that discretion in the criminal law makes no law at all. So cops can arrest you for whatever they want, and prosecutors will find a charge to hang on you. And everybody is a criminal, if somebody says you are. And so when you combine that with, sort of the fundamental racist attributes of the justice system to begin with, of the legal system in the United States, you get this sort of disastrous effect of, if an individual cop is a racist, well, then so is the law. If you have this one cop that wants to lock up only black people and only arrest black people and only throw black people in jail, or a prosecutor that's like that, well, then they've got free reign to do that because everybody's always breaking some kind of law somewhere. Go ahead.
I was just going to say, and I think that's one of the things that people are often surprised at is the lack of oversight. Even my students, right? It's like, they read about all these rights, like the defendants have all of these particular protections and and again, the Supreme Court created all of these rules that don't apply in
not even in a civil
setting.
Context, not even in a civil context. So I teach the 1983 class here. And, I think you go in, if you're really naive about things, you might go into law school thinking, well, if a cop does something bad and brings charges against people, then he's probably going to get fired and maybe even prosecuted. And that's just ridiculous. It has been a ridiculous proposition for most of American history. I hope things are turning around a little bit now. But my students are often surprised to find that, they can do all kinds of terrible things and face no civil repercussions at all, because who's going to hold them accountable?
No even reprimand. I think if you it's the cop isn't going to get anything done to him, and the prosecutor, right? Prosecutorial misconduct, is basically something that, we don't do anything about almost all of the time. And you can see what a dangerous brew that is, particularly if you are a black person in this country, right? Where we know, many individuals carry not only implicit racial biases, but explicit biases. Right. And there's no oversight at all, oftentimes. So let me ask a question, which I imagine a number of our viewers may have right now, which is, well, but we have an adversarial system, right? It's not just the prosecutor. Why don't defense attorneys balance the system out? Why doesn't the judge at least step in and say, hey, this isn't right, this is unfair?
Yeah, because it's not what we do. A lot of that is I think during the 1970s, we were still sort of questioning our role in the legal universe, not just defense attorneys, but everybody, judges too, because this wasn't like, from the 1830s on, it blew up in New England, but in other parts of the country, we're just kind of like, I don't know, do we really want to do this? Do we want to just have everything end in a guilty plea and give all these powers to the prosecutor? And in the 1970s, you've got, these national councils of lawyers making recommendations that we should end plea bargaining altogether, and professors were, writing these papers about, well, here's the future of plea bargaining, and there should be no plea bargaining, or we should severely restrict it, or whatever. Well, the United States Supreme Court didn't see it that way. And so I write, the very first thing in the book that comes up is this 1978 case called Hayes versus Bordenkircher. And in Hayes, that happened right down the road here in Lexington, Kentucky. You've got a 29-year-old horse transporter that gets caught writing an $88.30 bad check at a grocery store. And they pop him for it, and he's got a prior felony. And the prosecutor says, well, listen, I want you to take 5 years on this check. And Paul Hayes is like, I don't want 5 years on a bad check. That doesn't sound like a very good deal to me. He's like, okay, well, you either take 5 years on this bad check, or I'm going to charge you with this higher thing, this habitual offender statute, and you're going to get life. And he says, all right, well, let's go to the jury, because I don't really think that I think I'm innocent, and also this is just too much time to talk about for a bad check. Goes to trial, gets hammered, gets sentenced to life in prison. Takes that case up to the Supreme Court. And, that was the kind of practice that was going on all over the country at that time, but it wasn't really so much talked about. It wasn't really like openly acknowledged, and it hadn't been legitimized by the Supreme Court yet. But the Supreme Court says, yeah, that's fine for him to just bet with his life like that. And if, the prosecutor's job is to persuade the defendant into giving up his right to trial. And Mr. Hayes wasn't persuaded, so tough luck. Too bad. You get to do life in prison for a $90 check. And from that point on, I talked to the lawyer that represented Paul Hayes in the Supreme Court for this book, Vince April, who practices right down the street here, still in practice. And, he said that when he was doing Hayes's parole application, that he got all these letters from prosecutors all over the country saying, I would never, ever do something like that. I would never threaten somebody with all these higher charges just because they wanted to go to trial. I don't know if all that was true or not, right? Who knows? I'm sure it was true for some of those prosecutors. It is not true now. We're 2 generations out from the Hayes case. And when defense attorneys get to court, just going back to your question, I swear to God, I'll answer it. When defense attorneys get to court and they get a case, they know that the prosecutors basically have all the cards. So they can use whatever penalties, infinite time in prison, the death penalty, whatever, to coerce or cajole or compel a defendant into taking some kind of deal on some kind of charges. And so we're at a point now where that's what we expect. I think that's what the defense bar expects. You're going to go in, you're most likely going to take a plea to something. We just got to figure out what the best deal is we can get for you. For the private bar, the problem is one of capitalism. I mean, there's virtually no private bar to speak of for blue collar crime anymore. But for the ones that are out there, it's a problem of capitalism, because you've got to, take on as many cases as possible to keep the lights on every month and to make a little bit of money. And so, to keep those cases moving as fast as possible, you want to get them pleaded out as quick as you can, especially if a client that has trouble paying.
Yeah. And I think, that's a great insight, which is that plea bargaining can be a problem on both ends, right? So it can mean that poor people get much longer sentences than they ought to get. And it can also be, right, guilty rich people can get much more lenient sentences, right? So, look at what happened to Epstein in Florida. What had the length of his sentence, right? He got something like 13 months, even though they had mountains of evidence related to, his sexual assaults of underage girls. Why? Well, he hired, the 5 most expensive defense attorneys in the United States. And to quote Alan Dershowitz, we out-lawyered him, meaning the head lawyer in Florida, never mind the victims. So I think that, this is not, for people who think plea bargaining is just, hurting guilty, innocent, poor people or people who are serving more than they ought to. It's also letting people who have done really horrible things go out and conceivably offend again.
And that's
now
where
I
you
want to come
see
back.
oh, I'm sorry, go ahead.
Oh, no, go ahead.
I was going to say that's where you really see the gaping wound of classism in the system, right? You know, and it's sort of like I think a lot of people have a hard time accepting that an institution like especially something like the courts could be classist or racist or have, you know, like that those tendencies could be baked into the institution. But, you know, if you look, I mean, it's a system that prides itself on kind of staying the same for centuries, right? You know, that's the whole thing that we like to say that, oh, we did this, you know, we've done this sort of thing for centuries. So if you look at tactics like, you know, cash bail, or, you know, having to hire an attorney to begin with, or, you know, getting to select your own attorney depending on how much money you have, or having the luxury of firing that attorney if they're not doing a good job, or the plea bargain. I mean, these are all tactics that were handed down from when the system was explicitly classist. We just don't say it out loud now.
Yeah, and I think one of the things that is really interesting about, you know, the history and the current practice here is just, you know, kind of the incentives for any individual party to actually be able to change things. I think for the people in power, like, it works pretty well. The defense attorneys don't have the power to change things. The prosecutors like this because this maximizes their power in the world. And the judges, having talked to a lot of judges, I actually get the sense that a lot of them have some problems with some of the cases that come before them. But they are just so used to, like, this is where I always sit. This is what I do. Everyone kind of rubber stamps these things. I remember talking to a judge in Ohio at a judicial conference who said, yeah, you know, the other day I really gave it to one of the, you know, the prosecutor, because I thought, but I said, well, but what did you do at the end of the day? It's like, well, yeah, at the end of the day, I did kind of rubber, but I told him that I didn't think that this was right. And I think, you know, that's one of the tragedies here is I think a lot of people actually sense that this doesn't work. And I think one of the aspects of it that I'd like us to maybe circle back is kind of how it undermines the truth-telling aspect of the law. You know, you mentioned here, right, the kind of overcharging that happens. But one of the things that's also funny is how early in the process these pleas happen, right? Oftentimes, we haven't had a chance to actually test the evidence. We haven't actually had a chance to even see what the other side, it's all bluffs. It's all like, you're going to lose, and we have all this evidence, but we haven't actually seen all that stuff. And if one of the real points of having a process is to find out the truth, and we lose that.
Yeah, and just to go back to policing on that too, you know, if you've got cops that know that they're never going to have to testify, and this is why they can get away with doing whatever, you know, sort of racist or crazy stuff they want to do. If you've got cops that know that they're never going to have to, you know, show the goods in court, they're never going to have to testify, they're never going to have to present any real evidence for, you know, anything. On the one hand, and if they do and screw it up, then so what, you know, because there's no accountability on the other hand. But they know they're probably never going to have to do that, really, realistically, because once it gets into court, you know, a couple of hearings go by and this person's going to plead to something, whatever, before that cop ever has to get on the stand. So it creates a real disincentive to do any proper policing. You know.
And I love that aspect. I think you wrote at some point something about how, you know, plea bargaining is I think you used the term like chief enabler of bad policing. And I think that's exactly right. This is not a separate problem. This is the same problem because it's about a lack of accountability.
Yes.
And I think that's one of the funniest things is, you know, I think this is changing somewhat, but certainly when I was in law school, you know, whenever that 20 odd years ago, sitting in class first year, the people who wanted to become prosecutors were the most law and order, by the book, Boy Scout and Girl Scout, but mostly it was Boy Scouts, even then. And it's really interesting to then have that person go, and it's like the Wild West. It's not at all, like law and order. It's like make up the rules, play fast and loose, no accountability at all. And it's, very troubling. And I want to, before we get to question and answer from the audience, I have to ask the question, which I know is on everyone's mind, is can we do anything about this? This, you told me this long history. It seems involved in policing. This sounds terrible. Is there anything that we can do?
Yeah, I mean, I think so. And it sort of lies in the simple fact that just a little bit of a swing in the numbers of cases that go to trial can potentially make a huge difference. So, think about it. If we're in a situation where, we're used to 5% or less of all cases going to trial, you up that number to 10% or 15% or 20%. And you've got a dramatic increase in the amount of resources that have to be devoted to the process overall, right? So, you've got court staff, you've got, security, you've got the whole ball of wax, right? It just takes twice, three, however many times the resources. I think there's a quote that I've got in the book that's an old quote from former Chief Justice Berger, that talks about, well, if we're at 10% plea bargaining, we up that to 20%, we have to double our resources. That just makes sense. And his point with the whole thing is, and I think most people that throw out those kind of stats, their point is, well, that's going to crash the whole system if we do that, because it's going to create too much of a strain, and then everything's going to get blocked up, and then that's going to be the collapse of criminal justice and the end of our society. But in fact, when you look at places that have reduced the amount of plea bargaining or even just tried to restrict it outright, like in Alaska and to a lesser extent New Orleans, for a brief time in the 70s, they experimented with doing away with plea bargaining. And what happened was the system didn't crash, it adapted. Everybody was doing a lot more trials, for sure. But also the prosecutors got a whole lot more selective about what they were going to prosecute, as opposed to what we've got now, which is in many jurisdictions just sort of a churn and burn. It's like we're gonna hang everybody, we're gonna get as many convictions as possible, and we're like, let's get them through as quick as we can. Instead of doing that in New Orleans and Alaska, they started looking at these cases and saying, all right, well, I think the rejection rate for the cases that were being brought in Fairbanks, I think it went from 4% to like 44% in the first year of the pleading ban. And it made the cops get more careful. They cared more about the kind of cases they were bringing to prosecutors because they didn't want to see their cases go up in smoke. So everybody gets more selective. The system gets a little bit more intelligent. And how do we go about doing that? Well, I mean, whether or not to plead is one of the few things in the criminal justice system that is in control of the layperson, is in control of the defendant. And if we can sort of disabuse people of the notion that you have to go in and take a plea, because that's what people think right now. It's just culturally expected for people to go in, take a plea after a couple of hearings and get the best deal you can and go on. And so if you manage to swing people out of that sort of stupor of thinking that the only thing that they can do is take a plea, if you dispel that notion in just a small percentage of cases, I think you can start to see a pretty dramatic transformation in the system. That's the hope, anyway.
Yeah, and so I'd love to hear more about kind of the bottom up nature, because I thought that was one of the things that was really interesting in your book, because I think a lot of people come in and think, well, the only way we can change the criminal justice system is if those elites that you've been talking about, they change their mentality. And you actually say no. You say actually bottom up processes can really work here.
Because that's all you got. That's all you've got. I mean, what else are you going to depend on? The courts are terrible shape. What are you think you're going to take a criminal case all the way up to the United States Supreme Court in this day and age and get sympathy out of those folks? I don't think so. The courts, by and large, are just fine with the way we're doing things. And if they're not, they're powerless to do too much to change things. Legislatures, no, they don't care. Certainly not in the red state that I live in. Even though everybody is on the ground is sort of on board with criminal justice reform, like even the Koch brothers talk about criminal justice reform, and everybody recognizes that this is a festering wound that we need to do something about, but they don't do it, So I don't think that, there's just very few incentives for legislatures, for people at the top, anybody at the top, to do much of anything. And I think real change has always come from the bottom up in America. And I think this situation is no exception. If there's going to be real change made to the criminal justice system, it's got to come from the bottom up. I mean, you look at, the conversations that got started as a result of the George Floyd and Breonna Taylor protests. People here in Louisville were in the streets for 4 months straight. And what changed as a result of that? Well, maybe not much, but something did. You've got the county that's finally ponying up, a significant amount of money to pay for somebody that got shot by a cop. And that's never happened in the history of my city. So it's something. I think the only way to make changes to the criminal justice system is going to be from the bottom up. It's the only way we can do it. There's nothing left.
So with that, I have a note from Shane that there are people ready to ask questions. So Shane, we're ready to switch over.
All right. First off, incredible conversation. Thank you both so much for bringing to light a lot of issues, a lot of topics that are very important to St. Louis and the country at large. So I'm glad that this conversation is happening. There's so many incredible questions. I want to start with one up at the very, very top, early question, because this was something that came to my mind as well, because we have some legal experts in the audience, I'm certain, but I am not.
Sorry for the wrong that I said, legal expert.
No, they're just abbreviations, and I'm like, I have no idea what that means. So I'm thinking that it's probably something legal. But David asks a topic of conversation, wondering if you will talk about how other countries move cases without plea bargaining. And this was one of my questions that I'm wondering, are there countries that are doing this better than others, and how we might adopt some of their systems?
What I know about that is that nobody does it like the United States. There's no country in the world that has criminal justice outcomes that are as gigantic and terrible as ours. We lock up way more people than anybody in the history of the world. We lock them up for longer, et cetera, et cetera, et cetera. And I think the people on this call probably generally know that. Nobody else is doing that, and nobody else has a system of plea bargaining like us, including other common law countries, including the UK. And so you look at places that have closely related legal systems to ours: Canada, Australia, United Kingdom. India is a common law country, and India does 1% plea bargaining, something like that, out of 10 million cases a year. In Britain, I think the statistic is 75%. And they just, they don't have the same kind of outcomes that we do, not even close. And I think that lends some credence to the idea that if we swing our numbers just a little bit, we can start to make some pretty big transformations to the system. Now, in terms of, Adam might be able to speak to some civil law countries and how they do things. I don't know much about that.
Yeah, so I agree with all that, and just two little nuances there. I think one of the reasons, which Dan's already touched on, is these countries just don't lock up people so much. We don't prosecute, and a lot of these cases don't go to trials over there. That would go to trials here or be threatened with trials and therefore need to be plea bargained. And so I think that when you are not so high on criminalizing everything and sending so many people to prison, you can have a system that delivers justice a lot more through the trial. The second thing I think that's interesting about certain other countries is that, you know, when you remove the adversarial process, it actually can really streamline things quite a lot. Rather than delivering substantive justice, I think a lot of times we have become obsessed with kind of making sure that all the boxes are checked, and we go through like the procedural, you know, it's like doing this elaborate dance, and we kind of just, all we care about is whether the moves are done at the right moment and done correctly, as opposed to actually thinking about what the end goal is. And so I think in these countries where there's a lot more of sort of a unified system in which, you know, the prosecutor is kind of cast as the night watchman of the law, kind of caring more about making sure that innocent people are not prosecuted and guilty people don't get longer than they should get. You have a system that actually can operate much more efficiently. Now, I think there are things that are wonderful about our systems, but I think that unfortunately, a lot of the hard work to create all of these adversarial processes is one of the reasons we can't actually deliver trials to people.
There are a couple of questions about the discrepancy between public defender and district attorney pay, that or private attorneys. DPA. What, I don't know what that is. DPA. District
DPA is, yeah. He's not going to be a district attorney. It's going to be a public defender agency. That's a public defender agency in Kentucky, probably, is what the question is. If it's one of mine. Are you asking questions about the DPA? I can't hear you.
Well, so Brian is asking, would standardizing equalizing pay between DPAs and PDs be a step in the right direction?
Oh, maybe that does mean DAs then. Yeah, I think that probably does mean prosecutors and defense attorneys is standardizing pay between them. You know, I mean, maybe what good does that really do? I don't think that matters a whole lot, honestly. You're not going to find, I mean, you know, prosecutors are generally speaking not grossly more overpaid than public defenders. They can be. It tends to be a jurisdiction by jurisdiction sort of thing. You know, but the problem is not really how much anybody's getting paid. I mean, most of the public defenders are out there, you know, slugging it out, not because they're making a whole bunch of money, you know, but because they really believe in it. And I mean, that goes for the prosecutors too. So, I mean, I don't really see how tweaking financial incentives here does much of anything. And I think the conversation really is moot anyway, because you're not going to get states, if it's the state that's providing the public defense, or counties, or whoever's doing it, whoever's paying the tab, you're just not going to find a lot of appetite for them to up the budgets for public defenders, certainly.
Yeah, I agree on the skepticism there. I mean, I think, you know, there's part of me that thinks, well, if they had more resources, at least, they could actually, you know, do their more investigative work earlier on and feel more confident, you know, advising people to go to trial, and we can have a better outcome here. And so maybe it would help somewhat. But I tend to think, you know, I agree with Dan that I think the core problem is about the power of prosecutors, and you're not really changing that dynamic. The power of the police, the power of the prosecutors, that's still going to be in play. And so I think, you know, you need a deeper fix. I think there's you know, other reasons to pay people well who do public defense work. So I don't want to suggest that I don't think public defenders should be paid more. I do. But I think that, you know, if you really want to get at plea bargaining and address that, there are other more promising routes.
Yeah, I definitely think they should be paid more. I certainly don't mean to suggest that. But it's just a question of, even if you throw all these resources at let's say, I mean, the question that I get a lot is, well, what if you hired, 100 more public defenders per agency? And I think that's fine. Then you're getting a little bit closer to maybe striking at the root of the problem, which is, public defenders have an impossible caseload. So let's make it a little less impossible. I'm not sure that even really happens, because this is a situation in which, demand is always going to meet and exceed supply. So if you look at the rate of violent crime since the 1990s, that's gone, down by about 40%. And at the same time, people are still getting locked up. Like, we've almost doubled the prison population in that same amount of time. So it's like, I don't know that the system is really intelligent enough to adapt to, how much public defense is out there, or how much resources are being thrown at these cases. I don't know.
BT is asking, kind of, not really a question, but I want to get to this topic. So the system seems to be set up to fail under the weight of an increase of 97 and 98% in full jury trials. You mentioned, like, if we took 5 or 10%, or I forget what you said exactly, but so increasing it double of what we're taking to jury. Is there any hope of reforming this without decriminalizing a shit ton of behaviors and actions? And I'm wondering if if we should be decriminalizing more things so that more things are not going through the criminal justice system that shouldn't be.
Yeah, I mean, of course. I think there's a lot of stuff that ought to be decriminalized, but part of the point in my book is that the community has been so removed from the whole ball of wax when it comes to criminal justice that we don't know or really care all that much what is criminalized and what's not. And I think you can sort of safely assume it's everything. And I've got some quotes from state legislators in the book that say, yeah, something comes on my desk and it looks like a criminal justice bill, and I'm just going to vote for it. This looks pretty good, and it's going to make me unpopular if I don't vote for it. And, I don't care what sort of Frankenstein's monster it is. I'm going to vote for it. The title of the bill sounds good. So, there it goes. And there's this ram and jam that happens in state legislatures that just, obviously that needs to be stopped. But I think to get there, you have to re-involve the community in the criminal justice system and get a critical mass of people to care about it.
And the one thing I would add is to turn around the question a little bit, or the statement, and say, the system is failing under the weight of plea bargaining right now, right? It's not that if we suddenly start to address plea bargaining, it starts to, no, it's failing right now. Like, we have the weight of plea bargaining is weighing down our entire country. Our over-incarceration is weighing down our entire country. So the baseline here is failing. Once we do this, yes, it takes up more time, it takes up more resources, but that's climbing out of the hole that we've dug ourselves.
Yeah.
Let's get to David's question. So a pretty recent. David is asking, please talk about how incarceration is used as a coercive tool to drive criminal defendants into taking plea agreements, especially in the light of attacks on the Bail Project and organizations like that.
Yeah. Well, I'll tell you a story. And I had a client in a civil rights case who came to me after he spent a year locked up in a murder case. And he spent a year locked up because the police were pretty well convinced that he was going to flip on his best friend. Best friend is the target, right? Or not even a best friend, somebody he was running around with. So they're pretty sure that the friend is the guy who did the murder, but they charged my guy with murder just because. We got enough to charge him because it doesn't take anything. And so he sat in the cell because he couldn't pay the freight to get out, couldn't pay his bond. It was that so high, it was murder. And sat there for over a year. And, because he wouldn't flip. If at any point in time during that year, he'd have said, I don't know, maybe I'd like to tell you some more information about my friend and this murder that he did. which he didn't know anything about. He might have been able to get out, right? He might have been able to reduce his charges to some sort of, possibly to nothing. He might have been able to walk free. He didn't do that, spent a year in jail. And at his criminal trial, I've never seen anything like this before or since. The prosecutor gets up and asks the jury to acquit my guy. Says, please do not convict this man. Please do not convict him. There's not enough evidence to make this murder case. And he sat in jail waiting for trial for a year. And I mean, that's the price you're going to pay if you don't either play along or come up with some money, a substantial amount of money in a case like that. So, I mean, the effect of cash bail on the whole system is terrible. It allows, prosecutors and police, really ultimately, it's police that can do this. They make the initial decision with what to charge somebody with. And that often determines how long that person's going to sit in jail, and how high their bond is going to be. And it gives them a lot of coercive power to make somebody do basically whatever they want. Take a plea agreement, testify against somebody else, testify against themselves, confess to things they didn't do. And we've decided that we're going to give prosecutors every imaginable tool, every kind of dirty trick. And that, by the way, is another thing that sets us apart from the other common law countries. They don't do that in Australia. They don't do it in Canada. They don't do it in Britain. They're not allowed to do that kind of thing. Here we've just said anything goes because expediency is king. That's the number one principle. And so if it pushes this case through and if it gets a resolution, then we're going to allow it.
And I think that's the point that I just want to hammer on there, which is so important, is it's not always the threat of like some long sentence. It may just be, you don't have again, sometimes in a murder case, the bail might be quite high, but oftentimes it's like $1,000, $2,000. But for poor people, like $2,000 is a huge amount. So you're sitting in a cell. And again, our trials, it takes a very long time. It might be a whole 11 months, a year out. And so your choice, honestly, is take the plea and leave, right? You're not going to, there's not a prison term with if you take the plea, or you sit locked up in a jail until your trial. And so therefore, it's not like the thing that I'm so worried about is I'm going to get a long sentence. It's just the not taking the plea is sitting in jail awaiting trial. And that's why a lot of people take pleas.
So last question. I think we can get this in maybe before the hour mark. So Jamie says, this book, just juxtaposed to your work on Obergefell, is really striking in their parallel connections to growing social movements. After writing this book on reflection, are you hopeful about the trajectory of reform movements in criminal justice? If you were a legislator, where would you start on criminal justice reforms?
Oh,
yeah, it's a big question for the last one.
2 minutes.
Yeah. How about maybe just some like hopeful, anything hopeful?
This is the whole reason that I wrote the last couple of chapters of the book. In particular, the last chapter of the book does give me hope that we can squeeze something potable out of the lemons that we've been given here. Because I do have success stories in there from people, some of them formerly incarcerated, some of them former prosecutors, that have been working with grassroots organizations, working with, coalition, doing the coalition building that you need to do to get a critical mass of people involved enough in an issue to actually make real change, to make people at the top notice. And I think that's the only path really we have. I've said it before. I think it's really the only path that we have to lasting change. So yeah, I think it can be done. I think that there is a huge appetite, like public appetite, for criminal justice reform. And I think that appetite is actually bipartisan at this point. So I do have some hope that broader criminal justice reform can be accomplished. I just think that we're in such a tangle that it's going to take a lot, and it's going to take a really long time and a lot of effort. So.
And the one last thing is, I love the closing in your acknowledgments. you thank your children, and you say, right, that this is for them. They're going to be the ones who change the system. And I love that message going forward, because I think it is the young people who are going to lead this charge towards a better system.
And at the same time, sorry for sticking you with it. We tried, some of us.
Exactly.
All right. Well, I want to thank you both for this incredible conversation. I want to thank the audience for being here tonight and asking really incredible, fantastic questions. And a reminder that we have signed copies available for sale at left-bank.com. I shared a link in the comments how you can get one of these beautiful books with Dan's incredible signature that we have on our shelves right now.
I've never had my signature called incredible. Thank you.
It's really nice. Like, yeah, I like it. It's very loopy and very, it's artistic. But I cannot thank you both enough for having this conversation, for bringing this topic to a lot of people's eyes, and hoping for things to change.
Thanks so much.
Thank you so much. And Dan,
everybody buy Adam's new book. It's coming out next year. Look for it. Buy
another year.
He won't plug himself, but I'll do it.
So Dan, thank you so much. I just want to thank you for the book. One of my favorite reads of the year. And I really do think this is the kind of thing that we need to kick us all into gear in the reform movement.
Well, I'm so grateful for both of you, and thanks for creating this space and for all the support.
Have a good night, everyone.